My name is Abigail Brightwell. I'm a partner here in the Brayshaws employment team. And today's session is going to focus on two of the more significant changes which are coming out of the Employment Rights Act 2025 that will affect pretty much all employers, regardless of size and sector. Now, these areas are unfair dismissal. Specifically, we're going to have a look at the reduction of the qualifying period for being able to present unfair dismissal claims and the removal of the compensation cap. And secondly, I'm going to have a look at the new restrictions on dismissal and re-engagement, also known as fire and rehire. Now, for those of you who are familiar with our bite-size format, I'm hoping today will give you an outline of the changes coming into force, as well as some practical tips and what these changes mean for you and your organisation and what you can be thinking about now and putting in place in order to prepare. Today's session will last around 30 minutes in total. I will leave a few minutes at the end if I am able to for any questions, so pop anything into the chat and we will pick those up at the end if time allows. If we run out of time, happy to follow up by email. And finally, you will get a copy of the notes, or sorry, of the slides sent to you, so don't worry about taking lots of notes. And also we'll give you some action points at the end to pull together everything that we've discussed. So I think let's get ahead and crack on. Now, I've put on the slides, and again, you'll see that just some sort of background information in relation to the implementation of the Employment Rights Act. I don't propose to go through those in any detail, and you will see when you get a copy of the slides that we have put out a timeline graphic where you can see when some of the key dates, noting that some of these provisions have already come into force and when other aspects are expected to be introduced. But as I mentioned, today is going to focus on the two key areas of unfair dismissal reform and changes to fire and rehire. So let's have a look firstly at unfair dismissal. Now, just going to quickly start with where we are today. It's always a useful reminder, as I'm sure all of you know the current position, but worth reminding ourselves on where we are before we go on to look at what's changing. So under the current law, an employee needs 2 years continuous service before they can bring a claim for ordinary unfair dismissal. And that 2-year period has given employers a fairly significant degree of flexibility, particularly during the early stages of employment when you're still assessing whether somebody is the right fit for the role and the organisation. Now, there are some exceptions to this 2-year qualifying period, and employees don't need any qualifying service to bring claims for automatic unfair dismissal. So if somebody is dismissed for example, for blowing the whistle, or because they're pregnant, or because they belong to a trade union, then those claims can currently be brought from day one of employment. But for ordinary unfair dismissal claims, where the key question is whether the employer had a fair reason and followed a fair process, 2 years service is currently required. And in addition to that, currently an employer must give an employee written reasons for dismissal if so requested for an employee who has over 2 years of continuous service. So moving on to look at what is changing. Well, the original government plan was to make unfair dismissal a day one right, removing the qualifying period altogether. Now, that was a manifesto commitment from the government, but in the end, it didn't survive the parliamentary process, and after several defeats in the House of Lords, significant pushback from a number of business groups, the government reached what it's described as its compromise position in November last year, backed by both unions and employer representatives. And the result is that the qualifying period isn't going to be abolished, but it is going to be cut from 2 years to 6 months, which is a pretty significant reduction. Now, a survey published by ACAS in February this year revealed that actually the reduction to the unfair dismissal qualifying period is the aspect of, well, an aspect of the Act that is expected to have the second biggest impact on employers and workers. The first biggest impact that came out from that survey was the changes to sick pay. Now, Section 25 of the new Employment Rights Act will amend Section 108 of the current Act in order to make this change. And to mirror that, the qualifying period of service required to bring a claim in respect of an employer's failure to provide a written statement of reasons for the dismissal will also be reduced from the current 2 years down to 6 months. Now, it's worth stressing that existing cases where there is no qualifying period, such as certain automatic unfair dismissals, will be unaffected and they still remain a day one right as they are currently. And a further point to note is that the government has removed the power for future governments to change the qualifying period by statutory instrument. So in future, if any further changes to the qualifying period are going to be made, they will require a full act of Parliament. So I think that's pretty strong indication that this is, for now at least, going to be the settled position. So when's this happening? Well, the reduced qualifying period will be effective from the 1st of January 2027, and any employee with 6 months service whose effective date of termination, or EDT, falls on or after that date will be able to claim unfair dismissal. Now, there is an important nuance here because some recent transitional regulations, which came into force in the last couple of weeks, have confirmed that the reduction in the qualifying period will apply to cases where the effective date of termination is extended artificially and what's known as the notional EDT. And what that provision does is add the statutory minimum notice period onto the date of dismissal where notice wasn't given. So essentially what that means in practice is that if somebody is dismissed in the final week of December 2026 without giving notice or paying their notice, the notional EDT could fall on or after the 1st of January 2027, and that individual would benefit from the new rules. So employers who are looking to dismiss employees where the qualifying period of service remains at the 2-year stage will need to make sure that they serve notice on the correct day so that the effective date of termination or the notional date EDT, where applicable, falls on or before the 31st of December this year. So just to go over some very quick examples, it's fairly straightforward really. An individual or an employee who starts on the 2nd of July this year, by the 1st of January 2027, the date the new rules come in, they will have 6 months service, and from that date will have unfair dismissal rights. Similarly, somebody who started, say, the 1st of January this year, by the time we get to the 1st of January next year, when the new rules come into play, they will have a year's qualifying service and will also benefit from the reduced qualifying period at that stage. And an employee whose employment started on, say, the 1st of February 2025, if they're dismissed before the 1st of January 2027, the old rules would still apply. They would need 2 years service and they wouldn't yet have it. But from the 1st of January 2027, they again would be fully protected in terms of having unfair dismissal qualification under the new rules. So that window where employers might have the ability to dismiss for those who have less than 2 years service is closing fairly rapidly. So what does all this mean in practice? What are the potential consequences of these changes? Well, I think certainly we are likely to see an increase in employment tribunal claims. The government has estimated that reducing the qualifying period from 2 years to 6 months will bring 6.3 million more employees within the scope of unfair dismissal protection. And it has also stated that it expects 9,000 additional ACAS early conciliation referrals per year, of which it estimates 3,000 of those will end up going on to a tribunal, which really this is the largest expected tribunal system impact of any measure under the new Act. Now, the government seeks to justify this on the basis that allowing an employee with a lesser period of service to bring a straightforward unfair dismissal claim will potentially remove the need for those claimants to bring a more complex discrimination or whistleblowing claim, which doesn't require any qualifying period of service to present. And discrimination and whistleblowing claims typically take up more tribunal time to determine. They're often longer, more complicated claims. And so it's anticipated that by potentially reducing the number of those claims being brought, the burden on the tribunal system will be reduced, despite an increase potentially in the number of unfair dismissal claims. Now, it remains to be seen whether that's something that will actually happen in practice, and employees without legal representation may be more likely to continue to plead all potential claims, including discrimination and whistleblowing, particularly if they're using the assistance of an AI tool to help them with drafting a claim form. And it also means that even if more complex claims are reduced, but unfair dismissal claims, even if they are more straightforward, do increase, employers are likely to face an increased workload dealing with more unfair dismissal claims, which can still be extremely time-consuming to manage. Another consequence is that, and then the most immediate practical issue really is in relation to probation periods, and employers will have a much shorter period to assess the quality and suitability of an employee for the role. If your standard probation period is 6 months, then by the time that period comes to an end, the employee will have already accrued 6 months service. From the 1st of January 2027, they will have unfair dismissal rights, which would make a dismissal at that stage more legally risky and potentially costly. So this means that if an employer wants to dismiss somebody for not meeting the relevant requirements during their probation period, they'll either need to act quickly to make sure that dismissal takes effect before the 6 months mark, or be confident that they can justify the dismissal after that period as fair. And I think this is more likely to put pressure on managing the probation period and making sure that early reviews of performance are carried out effectively and in good time. And we will go on to have a consider about some practical steps that you can think about putting in place now in relation to probation periods. But before we go on to do that, I wanted to look at the other aspect of unfair dismissal law, which is changing, which is in relation to the removal of the cap on compensation. So as again, many of you will know, currently the compensation award in most unfair dismissal cases is the lower of either the statutory cap, which is currently £123,543, and that increases in line with inflation every year, or 52 weeks gross pay. This is different to discrimination and whistleblowing claims where damages are uncapped. And what is changing is that these current limits on compensation in unfair dismissal claims is going to be abolished. And the section of the current Employment Rights Act containing the numerical cap and the 52 weeks pay compensation award is going to be repealed entirely. There's no change to the basic award, which is used for in unfair dismissal cases and to calculate statutory redundancy pay. That will continue to be calculated as it currently is. And again, the limits of that are set out on the slides, and they increase in line with inflation every April. When is this going to take effect? Well, it's going to come in from the 1st of January 2027, again in line with the other unfair dismissal reforms. And an important point to note, in relation to the cap, it's the actual effective date of termination that determines whether the cap applies, not the notional extended EDT, which can add on the notice period, which would apply for the qualifying period. So to work out whether somebody is subject to the cap, you look at their actual date of termination. So an employee who might be dismissed before the 1st of January 2027, whilst they might benefit from the extended EDT in relation to the qualifying period purposes, they would still be subject to that cap on compensation. And that's a key distinction between the two areas. So in terms again of the consequences, well, this was not part of the government's manifesto, and until the final stages of the bill as it passed through Parliament, this change hadn't been pledged or indeed expected. So it did come as a little bit of surprise, and the government has explained that the it views the cap on unfair dismissal awards as, again, creating an incentive for claimants to bring more complex discrimination claims, again, which have an uncapped compensation entitlement, which are more complicated and take up more employment tribunal time. And by removing the cap on unfair dismissal compensation, it's hoped that that incentive would be reduced. Now, what this means in practice is that unfair dismissal claims are potentially likely to get more expensive, particularly for higher earners and those with generous benefits, as well as those who might have more limited re-employment prospects. And higher earners who previously might not have looked to pursue an unfair dismissal claim because the cap made it commercially unviable might now have more of an incentive to do so, because they could potentially pursue their losses in full, which could include things like pension losses, bonuses, long-term incentive plans, share schemes, etc. So again, we could actually end up seeing an increase in the risk, in the number of unfair dismissal claims being presented in the tribunal system, and with that, more lengthy remedy hearings potentially being listed. Settlement agreements for particularly higher earners may become more complicated and financially risky. We might see perhaps an increase in expectations around exit terms, particularly where their potential future compensation is more uncertain rather. And don't forget as well, the breach of if there's any breach of the ACAS Code of Practice on disciplinary and grievance procedures, could potentially see an uplift in compensation of up to 25%, and with uncapped awards potentially running into hundreds of thousands of pounds, a 25% uplift on those could be very significant. So how can you prepare for these changes coming into force? Well, in summary, the first step, what we would certainly recommend, is to review your probation periods and your probation policies and procedures. A 6-month probation period is unlikely to remain appropriate for most employees, and you may want to update your employment contracts and offer letters to reflect any new period that you might use instead, which will allow for any probation review and potentially dismissal if required to be implemented before the qualifying period elapses. Remember, if you are dismissing without notice, the law will add on that notice period onto the EDT. You might want to consider particularly your provision of benefits if they're tied to successful completion of a probationary period, and whether that might need to be revisited. And also making sure that your policies and procedures, particularly in relation to performance during the probation period, are really clear on the expected standards of performance. And linked with that is sort of making sure that managers are trained up to date and really understand the new risks, and that they're aware of how to set clear objectives, how to give timely feedback, and critically, how to keep good records. Managers are going to need to be able to identify and address issues early, holding regular review meetings with new joiners, discussing their progress, and as well as highlighting areas of concern. That's all going to become even more important than it is currently, and potentially might require a cultural shift in organisations where perhaps performance management has not historically been as rigorous. Some employers might also want to review their recruitment processes, ensure they're hiring the right people in the first place, given that it will become more difficult to dismiss an employee who's not performing well or is not the right fit after that first 6 months of employment. And as I mentioned, record keeping is going to be really key, and having systems in place to make sure all evidence of all objectives and deadlines, as well as any potential shortcomings in performance, conversations that have taken place, and training and support offered are accurately recorded and retained. You might want to have a think about how you will manage senior exits. Is this an area where you will be prepared to run a proper performance management process at board level? If so, who's going to be responsible for doing that? Or will you accept that settlement values might need to increase at a senior level? You may also want to consider your use of fixed term contracts, because employees on fixed term contracts between 6 months and 2 years will now be able to claim unfair dismissal at the end of that period, where they currently cannot. So you might want to consider whether the use of those contracts still remains appropriate. And then finally, it's worth remembering that there are no changes to the rules on mitigation. And in many cases where an employee successfully mitigates their loss, they get a new job after a short period of time, the removal of the cap may in practice have very little impact. But employers are going to focus more, we think, on an employee's duty to mitigate their loss. And claimants will need to have evidence that they have made appropriate efforts. So in cases, particularly in high value dismissal claims, employers should place more emphasis on obtaining good evidence of mitigation, such as suitable job adverts, statements from recruitment consultants to potentially reduce any compensation awards that might be awarded. Now, having taken you through a whistle-stop tour of the changes to unfair dismissal, I'm now going to move on to have a look at the fire and rehire reforms, because this is another area where the law is changing quite significantly, and the window to take action between now and when the new rules come into play is already reducing. So just as a reminder, fire and rehire refers to the practice of dismissal and re-engagement for the purpose of effecting a change to an employee's terms and conditions of employment. And it's historically been used as a mechanism to implement changes to a contract where employees simply won't agree to the new terms. Now, it's always been slightly controversial, but it has been lawful, provided that the employer has a sound business reason for the change and gives appropriate notice and follows a fair process. It's often been used as a last resort, but has been there as an option. Now, since July 2024, employers have been required to comply with a statutory code of practice on dismissals and re-engagements, which essentially says that they should be used as a last resort, and an unreasonable failure to comply with the code can lead to a 25% compensation uplift, but the practice hadn't been prevented. Now, the fundamental change that's been brought about by the Employment Rights Act 2025 is that dismissal and re-engagement is going to be severely restricted, and it will become a much less attractive option in order to change an employee's terms and conditions of employment. And it's expected that from the 1st of January 2027, the changes will be implemented through regulations. And in most circumstances, dismissing an employee for refusing to accept a change to their contract to vary certain key contractual terms will become automatically unfair. Now, the key concept here is what the Act refers to as a restricted variation, and a restricted variation will broadly cover changes to pay, hours, holidays and pensions. In other words, the core terms of employment. Other than in circumstances of financial difficulty, an employee will be automatically unfairly dismissed, where the reason or principal reason for their dismissal is either because the employer sought to vary the employee's contract of employment to make a restricted variation and they didn't agree to it, or they sought to make one or more variation and the employee didn't agree to several variations, which included a restricted variation, and also to enable the employer to employ another person or to re-engage the employee under a varied contract of employment to carry out the same or substantially the same duties as the employee carried out before they were dismissed. Now, it's worth noting that the Act is quite broad in terms of what counts as an employee's contract, and it could include express as well as implied terms, oral and written, and also terms that might be found in collective agreements, staff handbooks or letters that have been incorporated into the contract. So you cannot assume that just because something isn't signed, a written agreement, that it doesn't have contractual effect. Now, as mentioned, a restricted variation will broadly concern hours, pay and holidays, and the Secretary of State will have the power to add more to that category of restricted variations. And they will include things like reducing or removing pay, changing pension terms, varying total working hours, changing shift patterns, reducing a holiday entitlement, and also attempting to insert a variation clause into a contract covering any of those areas without the employee's consent. Now, as drafted, there doesn't appear to be anything in the new Act that prevents any valid flexibility or variation clauses already in place continuing to remain valid. And neither do the provisions prevent employers from hiring new employees who do have those flexibility or variation clauses within their contracts. Now, under the new provisions of the Act, the Secretary of State may introduce some regulations to make it clear that certain types of pay and expenses are out of scope, and the consultation on that definition, what sums should fall within or without of scope, closed in April 2026. Now, there is one exception to this prohibition on dismissal and re-engagement, but it is very narrow, and essentially a dismissal will not be automatically unfair if the employer can show that the reason for the restricted variation was to eliminate, prevent, or significantly reduce financial difficulties that were affecting or were likely to affect in the immediate future the employer's ability to continue as a going concern, and that the employer could not reasonably have avoided the need to make that change. A tribunal in those circumstances would still need to assess whether the dismissal was fair. It just means it wouldn't be an automatically unfair dismissal. Now, this is a fundamentally different test from the current sound business reasons test that's used. And the tribunal isn't simply going to ask what is in the range of reasonable responses. It's going to scrutinise the employer's actual financial position, consider whether the business was at risk of failing, and whether the contractual change could have been avoided, which is all new territory really for employment tribunals. So in practice, unless you are a business in financial distress, generally at risk of going under, then the financial difficulties exception is unlikely to help. And for the vast majority of employers, fire and rehire in relation to restricted variation is simply not going to be an option. Now I'm going to move on to have a look at some of the consequences of this, because most employers will at some stage need to revisit their employment contracts and update those, whether that's to reflect changing business needs or to respond to economic pressures or to implement organisation-wide upgrades. And the difficulty is that under this new regime, if any proposed changes amount to a restricted variation, the employer will face the risk of an unfair dismissal claim. And this risk is amplified because of the changes that we've discussed in relation to the reduction in qualifying periods and uncapped compensation awards for unfair dismissal, which means that the potential exposure could be far higher than it is currently. So how can you prepare for these changes? Well, as a starting point, audit your contracts, go through your template employment contracts, identify what terms you've got relating to pay, hours, holidays, shift patterns, pensions and benefits, understand what's genuinely contractual and what might have come contractual through custom and practice and what might amount to a restricted variation. Review and strengthen your flexibility clauses. If you're going to do so, it's best to do it now before the changes take effect. And you will still be able to rely on existing flexibility clauses, but do bear in mind the limitations that case law places against the use of those flexibility clauses. Make sure that they're drafted as widely and robustly as possible. Plan ahead if you are thinking of making any contractual changes, particularly to pay hours or shift patterns. Start that process now. Consultation can take a long period of time, and if you are looking to effect any dismissals and re-engagements, you'll need to make sure you do that before the 1st of January next year, because once the new rules are in place, that option will effectively disappear. If you are using fire and rehire, I would suggest you approach with caution and make sure that you are following the code of practice, and have a look at whether there are any other methods. You might want to have a focus on achieving agreement rather than imposing changes under the new regime. Negotiation, consultation and incentivisation are going to be increasingly important. And finally, train your decision makers. People involved in the consultation processes need to understand what the new rules mean, what effect they will have, what evidence will be required if things don't go to plan, and why a genuine documented consultation process is essential. Now, I've got an eye on the time, so I do appreciate we've slightly gone over, but just to pull all of that together, I think the key takeaway is from the 1st of January next year, the employment law landscape will shift fairly significantly. Now is the time to start preparing for these changes and to get your business into a strong position when the pay changes do take effect. And as a minimum, we'd certainly recommend you review your employment contracts and ask yourself the questions: are your probation periods fit for purpose? Are your flexibility clauses as wide as they could be? Do you have any terms that could create a restricted variation problem? And have you got any clauses that may have become contractual through custom and practice? Now, that brings me to the end of today's session. As I said, you will get a copy of the slides. Thank you very much for joining me today. I hope you found it a useful session. Please do keep an eye out for our next webinar, which is going to focus on another aspect of the Employment Rights Act. I'm going to have a look at the family-friendly rights and 0 hours arrangements. But that leaves me to thank you for attending and have a lovely afternoon. Thank you.